We are now we've also joined by Utkarsh Saxena. Utkarsh is a lawyer who is also a petitioner in this case. He was at the Supreme Court today. He was he was presenting himself. Utkarsh, thank you for joining us. Utkarsh, if you could tell us, what were the highlights today at the hearing for you?
Yeah, no, Pramanko, thank you for having me. Firstly, apologies. I was getting out of court and took a while to get on. So first, in the first half, there was a discussion around what would be the canvas and the ambit of the hearings. And because there are so many petitioners and so many issues that are involved, what exactly would the court get into? The first thing that was discussed was, do we only deal with the secular laws, which is the Special Marriage Act, which is what a lot of other petitioners are challenging, or do we also go into personal law, so the Hindu Marriage Act, Christian, Muslim, Parsi Marriage Act? And finally, there was an understanding that the ambit of this litigation and this hearing would be focused on the secular laws. So we will only be dealing with the Special Marriage Act and not going into any of the issues related to personal laws. The second this issue that took up some discussion was what is the right forum for this hearing, because the government and the Solicitor General argued that this was not the right forum, that this was in fact an issue that needs to be discussed by Parliament because there are social issues involved. Those arguments were heard, and the court finally decided that both sides will respond to what's called maintainability, whether in fact this issue is maintainable in the court, and the court will take a decision. But the court didn't believe that it was a reason and a stage enough for you to completely end the hearings and only hear maintainability first and decide whether the court was the right forum or not. That will be a part of the litigation and will be discussed. And then thereafter, in the second half, Mr. Mukul Rohatgi, who was appearing for the petitioners, opened arguments on behalf of the petitioners and basically walked through some of the major developments in LGBTQ rights jurisprudence, starting with the Nalsa judgment on trans rights to Justice Puttaswamy judgment, which identified privacy as a fundamental right in the Constitution, to, of course, Navdeep Johar, which decriminalized homosexuality. So the second half of the day was spent on reading a lot of the case law, what was laid out in there, which in our view could be a bedrock for further advancing the cause of queer rights, and using that, the language in those judgments and the rights expanded in those judgments to further advance some of the civil rights that we are discussing here. So I think that was the large sort of overview of the issues that were discussed in court today.
So as a layperson who has very little understanding of law, if you could tell us, break it down for all of us who are interested in the matter but don't know how things proceed. Does it mean that a judgment on this is anytime close, or does it mean that this is the first step? How does it proceed from now?
So the way it moves forward is, right now we'll have hearings for the next 2 to 3 weeks, where first the petitioners will argue on all the issues related to the Special Marriage Act. I heard Meenakshi just talking about the notice and objection regime, which is a big part of the challenge. So all those issues will be argued. Probably next week, the government will make a rebuttal and reply to our positions and maybe argue some of its own points on maintainability. And then we will do a rejoinder after that, which could go into week 3. And by that stage, the arguments will end and the government will end the hearings and reserve for judgment, which means that it's with the court now. They will deliberate upon it, because the court goes into summer vacation post mid-May. May, June will basically be taken up by the court to deliberate between themselves, decide between the bench, write the judgment. And I mean, it's hard to predict. There's no timeline actually written in court, but most likely it will be pronounced sometimes after the vacation, once the court reopens. So we could be looking at a judgment sometime in July or maybe August.